Hi everyone. As we already noted, due to pandemic COVID-19 virus in the world, all the colleges could not continue their classes in college premises. That's why, as per the directives of UGC and Bar Council of India, it is our obligations as a assistant professor to conduct the online classes. It may be in PPT, or it may be in Zoom apps, or it may be in the YouTube, Facebook, any of the online modes. That's why, in compliance with the orders from UGC and BCI, from today itself, I am going to conduct my online classes from today itself. Okay. Today we'll discuss under the heads of privileged communications from sections 122 to 132. Here, at first we have to note it, privileged communications, it also comes under the heads of competency of witnesses. Here, now privileged communications, its meaning and basic concept. At first, we have to know. Now, privileged communications. It means communications between the parties not permitted to be disclosed in court proceedings. Privileged communications are made in a private setting and are protected from disclosure to third parties. The rule of privileged communication exists because privacy of confidential relationship is valued in the society. This is why privileged communications are not admissible as evidence in court proceedings. The privileged communications of a witness means the right of a witness to withhold evidence to disclose certain matters. There are certain circumstances in which certain persons are not compelled to testify. Certain persons cannot be compelled to give evidence in the court proceedings. And a witness cannot either be compelled to disclose, or even if the witness is willing to disclose, he will not be permitted to disclose. This is the basic concept of privileged communications. At the moment of the proceedings, the parties of the proceedings, under certain circumstances, whatever comes under the privileged communications of the parties, it cannot be disclosed, it cannot be compelled to disclose at the moment of the testifications, at the moment of the examinations of the witnesses and the judicial proceedings. It may be in civil proceedings or it may be in criminal proceedings. This is the basic concept of privileged communications. Now we have got now the relevant provisions. We have to know it is given from sections 122 to 132 of the Indian Evidence Act. Now we are going to discuss sections one by one here. Now at first sections 122. Section 122, it provides about the communications during marriage. This section 122 prevents communications between a man and his wife from being disclosed. Marriage inspires confidence, and confidence inspires openness of heart and feeling. This enables a married person to make a clean breast of everything to his or her spouse. Naturally, therefore, such matters should not be. Naturally, therefore, such matters should be free from the risk of being disclosed. Section 122 directly provides that whatever the communications and conversations between the married spouses, it cannot be disclosed due to the confidence between the married spouses. The privilege under section 122, it admits of certain exceptions also. These exceptions are as follows. Now, number one exceptions: acts apart from communications, which doesn't come under the privileged communications. Number one provides that a wife can be testified, a wife can be examined as to what her husband did on a certain occasions, though not as to what he said to her. Number one exception says about it, a wife can be examined in court proceedings as a witness, not as to what they have did conversations between the husband and wife, but here the acts of the husbands on certain occasions, it can be examined by the wife with the relevant issue, with the relevant matters under inquiry. Whatever the husbands did on certain occasion, did on certain time, did on certain circumstances, it only says about the acts of the husbands, not about the conversations, not about the direct communications between the husbands and wife. Therefore, number one exceptions, it provides that here acts of the husbands on certain occasions can be examined by the wife in judicial proceedings. Number one exceptions provides about this. And the number two exceptions, evidence by third persons. It says this, communications or conversations between husband and wife taking place in the presence of a third person, or when overheard by third persons, can be testified to by the third persons. The privilege is that of the parties to the marriage and not of others. Here, number two exceptions, it provides about the conversation and communications between the married spouses, if it is made to the third persons or if it is overheard by the third persons, then it can be testified with the help of the third persons who have heard, who have overheard their conversations. That is, exception number two provides about this. Now the exception number three, waiver of privilege. It says that evidence of a privileged communications can be given by a spouse with the consent of the party who made the communications or with the consent of his representative in interest. This is known as waiver of the privilege. Waiver may take place by reason of an advance consent to the disclosure or by the fact that the husband or the wife has gone to the witness box to testify and the other spouse has not in good time objected to the disclosure. Here, number three, exceptions. It says about the waiver of privilege. That means the married spouses, they can give up their privilege of communications by their own consent. That is, it is allowed in the Divorce Act and divorce proceedings, and under the section 125 of the CRPC for the maintenance of the wife and children. In these cases, this waiver of privilege with the consent of the party itself, it is allowed. That is, in these cases, the privileged communication is not protected. And number four exceptions, crimes or suits between married persons. The last words of section 122 clearly recognize these exceptions by providing that such communications may be disclosed in suits between married persons or proceedings in which one married person is prosecuted for any crime committed against the other. If a husband is being prosecuted for any offense which he has committed against his wife, the wife may be disclosed any communications made to her by the husband and which is relevant to the matter in questions under inquiry. Number four, exceptions of the privileged communications. Here, this exception provides it. A privileged communications given to the parties is not protected when the suit is between the marriage spouses itself. In civil proceedings, if the wife and husbands, they themselves the plaintiff defendant, then and in criminal proceedings, if the husband is prosecuted for the offense committed against his wife, then the wife can be testified, then the wife can give in evidence of direct conversations between these married spouses It is not prosecuted within the marriage process in these cases. Exception number 4 says about this. In cases of civil proceedings or in cases of criminal prosecutions, if it is between the marriage spouses themselves, then privileged communication not to be disclosed provided under section 122, it is not protected. Under exception number 4 of section 122 provides about this. Okay, now we got the concept of section 122, provisions of sections as well as the exception part also. Okay, it is gone. Now section 123, it provides about the evidence as to affairs of state. This section 123 protects unpublished state records from being disclosed. The document must be related to the affairs of the state, and its disclosure must be against affairs of state or against public interest. Unpublished state records are not permitted to be disclosed. The only exception that they may be disclosed within permissions of the head of the department concerned. The head of the department shall have an absolute discretion to give such permissions. Now, section 123, we got that. It is given prohibitions to disclose some unpublished official records which related with the affairs of the state. That is, based on the public security, these unpublished official records of the state government, of the sovereign authority, whatever the unpublished official records, it cannot be disclosed to the public. Section 123 directly prohibits this. This comes under the concept of privileged communications. It cannot be compelled to disclose whatever the unpublished official records. Okay, section 123 gone. Now section 124, it provides about the official communications. Section 124, this section gives a privilege to public officials to refuse to disclose matters which are brought to their knowledge in official confidence. The requisites of this privilege are that there should be a public official. A communication has been made to him in official confidence, and that he has a discretion to refuse its disclosure on the ground that public interest would suffer by the disclosure. Yeah, section 124 we quoted. Whatever the public officers, public servants, they have the confidential informations about the official communications regarding the running of their office or running of administrations, whatever the confidential official communications. These confidential official communications cannot be disclosed by the public servants, public officers. Section 124, it directly prohibits. That's why it's come under the privileged communications. It cannot be disclosed by the public servants or public officers. Okay, now section 125. Information as to commissions of offences. Here, this section provides about information as to commission of offences. Here, it says that whatever the magistrate and police officer or the revenue officer, they could be testified, they could be examined about from which sources they have got the informations of the commissions of offences. About this, section 125 provides about this. It is given for the magistrate or police officer, or it is for the revenue officer, whether they have to disclose this information or not, whether they could be testified about this information or not. Here, section 125 directly says that this section is intended to encourage people to give information about offences by protecting the source of information. For otherwise, no one would like to give such information. No magistrate or police officer can be compelled to disclose how and from whom he got information about the commission of an offense. Similarly, no revenue officer can be compelled to disclose how and from whom he got information about the commissions of an offense against the public revenue. That is, yeah, this section directly prohibits the magistrate or the police officer and the revenue officer. They cannot be compelled to disclose from which reliable sources they have got the information about the commissions of certain offences. It is directly prohibits. It comes under the privileged communications for the magistrate or judges or police officer or revenue officer. This authority cannot be compelled. Magistrate, police officer, revenue officer, they are not bound to disclose such reliable sources from which they have obtained about the commissions of certain offences. That is. Now, section 126, professional communications. Section 126 provides about the professional communications. It just provides for the advocates, lawyers. It prohibits the lawyers, advocates from disclosure of communications, whatever they have done with the clients under the professional employments. Yeah, these sections given that communication between advocates and clients or the professional communications are not permitted to be disclosed. The prohibition extends to all communications made in confidence pertaining to any pending or contemplated case or for the purpose of soliciting professional advice. The reason for these prohibitions on disclosure is to encourage litigants to communicate fully and frankly with their lawyers, advocates, without any fear that the information given by them can be passed on to the opponent or to the court. In the absence of these prohibitions, it would have been difficult for anybody to get the best professional advice. Here, this section 126, it gives prohibitions of the advocates. Whatever they have professionally communications with each other between the advocates and the clients. Yeah, advocates cannot be disclose this information or communication by the clients. It is the prohibition given to the advocates or lawyers under the professional employments. That is. Section 126 provides about this. Now we got the concept and the section 127. Here it provides that section 126 to apply to interpreter citizenship. Section 127 provides that whatever the provisions given in section 126 for the advocates and lawyers, these provisions also apply to interpreters of the courts. That is, here this section reads that this section makes it clear that the prohibition contained in section 126, that is the professional communication between the advocate and the client, applies also to interpreters and the clerks and servants of the lawyer. That is, because reason is that they are also likely to come to know of the confidential informations relating to litigations. Reason behind is that they are also come to know about the confidential informations of the litigations. That's why these privileged communications provided under section 127, it is given prohibitions to the interpreters, clerks and servants of the lawyers, advocates. They cannot be disclosed or they cannot be compelled to disclose. They cannot be testified, they cannot be examined about these privileged communications in the court. It is. Now we got the concept of section 127. Now the section 128. It provides that privilege not waived by volunteering evidence. That is. Here, this section reads that it provides that if the party making the communication himself or at his own instance or otherwise gives evidence of the matter covered by the communications, that doesn't amount to waiver of the privilege. Even if such party calls the lawyer as a witness, it will not amount to a consent to disclosure. But if he questions the lawyer on the very matter of communications, that will amount to consent, and by reason of it, the lawyer can disclose the communication. Here, section 128, it provides that if the party they have called as a witness whatever they have communicated with the lawyer, that is, it doesn't mean that they have waived the privilege. They can just the lawyers can be asked on the other issue, but it cannot be asked about the direct conversation between the client and the advocates. Here, section 120 provides that. Here, Lawyers can be summoned to witness in the court for testify in other issue, but not the issue of matters of communications between them. Section 128 provides about this. Privilege not waived by volunteering evidence. That is. And now the section 129. It provides about the confidential communications with legal advisors. That is. Here, section 126. Whatever you go in section 126, it prohibits a lawyer from disclosing matters which have come to his knowledge from his client for the professional purpose. But in section 129, here, on the other hand, places the client beyond the range of compulsions as to matters which have passed between him and his professional legal advisor. That is, the effect of this section is that a person cannot be compelled to disclose any confidential communications which has taken place between him and legal professional advisor. Here, this section 129 provides that whatever the party they have communications with the legal advisor about these informations, the court cannot compel this party to disclose. This party cannot be testified, cannot be examined in the court. Whatever they have communicated, whatever they have taken suggestion, information from the legal advisors, it is given for the party, very party who have taken suggestion from the legal advisor. The court cannot be compelled to disclose this party in judicial proceedings. Section 129 provides about this. Now the section 130, it provides about the production of title deeds of witness, not a party. Here, an ordinary witness, namely a witness who is not a party, cannot be compelled to produce. Here, a witness who are not party themselves, they cannot be compelled to produce under the following subjects. Number one says that his title deeds to any property. If the witness is not party to the proceedings itself, he cannot be compelled to produce his title deeds of any property. And number two, it provides that any documents by which he became the pledgee or mortgagee of any property. Here, number two says about the pledgee who are obtained the another's legal title under the pledge. That means obtained for the performance of some debt which were promised by the owner of the property by giving security as their property. There is this pledgee and the mortgagee, whatever they have obtained the another's legal title as a security of the payment of the loan. Yeah, this pledgee and mortgagee, if they become the witness of the court, they cannot produce the title of the property before the court. Number two provides about this. And number three, any documents which might tend to criminate him, and any kind of document which may be criminate himself, criminate the witness, it cannot be produced by the witnesses. It cannot be compelled to produce in court proceedings from the witnesses. Here, but he can be so compelled if he has agreed to produce any such documents with the permissions, with the persons seeking its production. But these subjects may be produced if the witness they have met agreements with the party who seeking to produce these documents. That is, they have to make agreements. If the witnesses witnesses are compelled to disclose these titles of the property, here they have to make agreements with the party which is seeking its productions. Now we go to section 130 concept. Now this section 131. It provides about the production of documents or electronic records which another person having possessions could refuse to produce. It provides that the effect of the provision is that if any person is entitled to refuse the production of a document, the privilege or protection of the document should not suffer simply because it is in the possession of another. Thus, any such person who is in possession is not compelled able to produce it. Section 131, it is something similar to with this section 30. It is said that if the party, suppose the documents are in their possessions, this party they cannot be compelled to produce these documents. It doesn't deny that their legal title belongs to the other's possessions. That is, whatever we got the concept of the pledgee or mortgagee who are obtained their legal title. Under this section 131, it provides that the pledgee and mortgagee they can be prevents, they can be prohibited from production of their legal title. That is the owner of the property who are legally entitled, who are legally title of this property, they can prohibit the pledgee or mortgagee from production of the documents before the court proceedings for examinations, because the witnesses they are not party of the proceedings, they are not party to the litigations. That's why the owner of the property they can prohibit from disclosure of these titles of property. Now we got the concept of section 131. Now the last section of section 132 of privileged communications. This is the last sections and relevant provisions of privileged communications, section 132. It provides that witness not excused from answering on the ground that answer will criminate. Section 132 provides that witnesses not excused from answering incriminating questions. Where a question put to a witness is relevant to the matter in issue, the witness can be compelled to answer it and he cannot be excused from answering it simply because the answer would tend to criminate him or expose him to civil or criminal liability or to a penalty or forfeiture. Here, this section provides that whatever the matters, it is directly an issue. It is if the court is examined under this, then the court, then the witness, they must have to ensure, although they are incriminate about themselves. Here, the provisions, however, protects the witness. It provides that if a witness has been compelled to give an answer, his answer should not be used to subject him to any arrest or prosecution, nor the answer can be proved against him in any criminal proceeding. Here, protection to witnesses is also provided under this section 132. Although he has disclosed some information who are directly under the issue or who are directly under the relevant fact, although it is incriminate him, the witnesses must be excused under these provisions. He cannot be arrested, or the witness cannot be arrested. The witness cannot be prosecutions. About the answer can be proved against him in any criminal proceeding. Whatever the witness given answer in the court, although it is incriminate him, he cannot be prosecuted. Witness cannot be prosecuted against his answer. Protection is given to the witnesses. The answers which the witness is compelled to give should not constitute any evidence against him. Whatever the answers given by the witness, it cannot be used as evidence against the witnesses. That is, this protection is given to the witnesses. Here, witnesses are liberty to ensure, although it is incriminate him, which are directly matters an issue. That is, it is based on the public interest. That's why protection is also given to the witnesses. That is, these answers given by the witnesses cannot be used as evidence against the witnesses. They cannot be arrested, they cannot be prosecuted. That is. But if the answer is false, the witness may be prosecuted for giving false evidence. But one concept is also given here. But if the answer given by the witness is false, if the witness is giving the false evidence, then the witness may be prosecuted for giving false evidence. That is, here section 132 provisions also we got the concept. That is, now today we have discussed up to section 122 to 132. It covers the concept of the privileged communications. Section 122 to 132, it is the related provisions of the privileged communications. Under these matters, the parties, they cannot be testified, they cannot be examined in the judicial proceedings. Okay. Now, I hope that you have got the concept up to this, whatever we have discussed today. Okay. Meet you in the next discussion. Okay. Bye. Have a nice day.